This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about sovereign immunity and why waiver of sovereign immunity does not apply to federal statutory claims. The doctrine of sovereign immunity is an ancient concept. It is the long-established view that a sovereign such as a state is infallible and thus immune from suit, absent the state's consent. The General Assembly of Maryland provided such consent in the Maryland Tort Claims Act, which waives the state's immunity. However, in a case called Michele Williams versus Morgan State University, the Maryland Supreme Court decided on August 14, 2023, to respond to the Fourth Circuit Court of Appeals question regarding its evaluation of the state statute waiving the state's immunity to a tort action in a court in the state. The original court action was moved to federal court. Michele Williams sued her former employer, Morgan State University, or MSU, and her former supervisor, Dean Wickham, in his personal capacity regarding her termination from the university. In an amended complaint, she added claims alleging retaliation, violation of the National Defense Authorization Act, and the American Recovery and Reinvestment Act. As to her federal claims against MSU, the appellant alleged that her termination by MSU was impermissible retaliation for disclosing that the university, primarily Dean Wickham, had overstated the university's operating costs to the Corporation for Public Broadcasting in the United States Department of Education and attempted to influence the 2016 Baltimore mayoral race by violating FCC regulations. Eventually, the Fourth Circuit certified a question of law to the Supreme Court, which was, quote, "Does Maryland's waiver of sovereign immunity for a tort action under the MTCA extend to federal statutory claims," close quote. Basically, the appellant worked from 2014 to 2017 as MSU's Director of Broadcast Operations, where she oversaw and managed MSU's radio and television stations. The appellant complained to MSU that she believed Dean Wickham's actions violated various federal and state laws and regulations. She also complained that MSU intentionally was inflating expenses in reports submitted to state and federal agencies to secure larger grants. She alleged that her complaints resulted in her improper termination in 2017. Under the MTCA, a party injured by the negligent act or omission of a state officer or employee within the scope of the officer's or employee's public duties may obtain compensation for that injury from the state. By its plain terms, the statute provides that the scope of the state's waiver of sovereign immunity is not waived for, among other things, quote, "any tortious act or omission of state personnel that is not within the scope of the public duties of the state personnel or two is made with malice or gross negligence." The other central component of the MTCA, in addition to its waiver of the state's sovereign immunity for tortious acts or omissions by state personnel, is a corresponding immunity from suit and from liability and tort for state personnel. The MTCA also contains certain limitations of the scope of the waiver of the state's sovereign immunity beyond those that are dependent on the actions of state personnel. The Supreme Court concluded, and so advised the United States Court of Appeal, that the MTCA does not waive the state's sovereign immunity for federal statutory claims. There is no question that MSU was and is an instrumentality of the state sharing in its sovereign immunity. Although the Supreme Court concluded that the text of the MTCA is unambiguous, it noted that its interpretation of the waiver provision is consistent with the Act's purpose and historical context. The MTCA states that it shall be construed broadly to ensure that injured parties have a remedy. But a broad construction of the MTCA is not necessarily an open invitation for any injured party to file a claim. Concluding that the General Assembly did not intend for a tort action under the MTCA to include federal statutory causes of action, the Supreme Court noted that the MTCA's waiver provision contains no express language indicating such a result, and the General Assembly, of course, knows how to effectively waive the state's immunity if that was its goal. Furthermore, extending the scope of waiver provisions to federal statutory claims is inconsistent with both the key neighboring provisions concerning the interplay between the state and a state employee's immunity in certain suits, as well as the MTCA's role as a gap filler scheme. The certified question posed by the Fourth Circuit and slightly rephrased by the Supreme Court was whether a tort action under the MTCA includes federal statutory claims. The Supreme Court's answer was no. It so held because after assessing the plain language of the MTCA, there is no evidence that the General Assembly intended to include federal statutory claims within the scope of the MTCA. In my opinion, everyone dealing with insurance for public entities, like the MSU, must understand the application of sovereign immunity that limits the need of such public entities to secure insurance to protect the governmental entity from charges that have not been waived. Insurance calculations should be limited to the needs of the entity to protect against those things where the state has waived sovereign immunity and not where sovereign immunity has not been waived. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll have access to the more than 4,500 blog postings, and every new blog posting, usually 5, sometimes 6 a week. You can also subscribe to the videos on YouTube and rumble.com. They're also free. And if you wish a great deal of information on insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publications or my locals community. Thank you for your attention.